Hello and welcome everyone to Immigration Talk Show. I'm Nipasa. I'm going to be a host for this session that's lined up, and I'm very excited. I hope you are as well. It's going to be a very interesting session as we've got a very important guest who's going to be joining us in a short while. And before we start off with our session for, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, thank you so much for joining us. Let me tell you that I've got good news that you can also participate in this session with us by commenting wherever you're watching us. We are live right now on YouTube, but you can also check us out on LinkedIn, Facebook, X, and on Instagram. Stay connected with us. And also, don't forget to ring that bell here on YouTube so that whenever we have discussions like these, you're notified. And another good thing is you can call us, dial in this number, and you can join us on call. The number is 425-436-6335, and the access code is 988-888. So, friends, yes, without further ado, please help me welcome our guest for today, none other than Attorney Chand Parvathaneni from SPB Law Firm, Dallas, Texas. Hi, Chand. Really good to have you back again.
Thank you, Nipasa. Yeah, really good to be back, and hopefully we'll have a very productive session today. We'll talk about the Visa Bulletin and how it's impacting people's ability to immigrate to United States, how long the processing times are, how for some people it is like really bad because some things are based on the country of birth, not on country of citizenship, etc. So we're going to talk about a couple of issues regarding the Visa Bulletin, the kind of timelines people are seeing before they can get a green card. That's one topic. And another topic is compliance regarding I-94. It is very, very important that people look at their I-94s. And there is a lot of confusion. We are seeing a lot of cases where people accidentally, they did not realize that their I-94 has expired. And there is a reason for that. People have their H-1B approvals. Then there is a CBP I-94. And sometimes people get confused. And many people, not intentionally, but accidentally they get out of status. So it is very important people have to look at their I-94s. There are very, very strict regulations on when somebody becomes out of status. There is something called last action rule. So we will talk about the importance of I-94 and how everybody should look at their I-94s, know what I-94 to look at to ensure that their status is always legal in the country. Because if they ever fall out of status, they are jeopardizing their careers, their immigration approvals in the future. So we'll talk about those I-94s and what people should do to ensure their status in US is always legal.
I'm ex- I'm really excited, Chand, for today's session, and I'm sure folks out there as well are very excited because I can already see, Ricky. Hi to you. He says hello, and Rag says hello, Nipa and Chand. Really good to have you both join us. And Ricky, thank you for your questions as well. We are going to take them up a little later in the show, so stay with us. All right. And Chand, yes, the visa bulletin just got out, so definitely a lot of people are having a lot of questions in their mind because they have been waiting since forever. They feel, no matter how long you have to wait, it feels very long all the time. So I have
Yeah.
this first question. If you can tell us, for family sponsored applicants from India and China, we are seeing around 9 to 19 years of wait time. And why are these timelines still so long? And
Yeah.
if there is any chance that they might improve.
Sure. So when we talk about the timelines, typically when we talk about family-based immigration, it is always China, India, Mexico, and Philippines. These are the only four countries that are heavily impacted. And the reason for that is there are a lot of these countries, the populations are large. So you have more people in the countries. And then on top of that, when you talk about Mexico or Philippines, they have a lot of family immigration to United States. And when we talk about family based immigration, so there are four kinds of family based immigration. Uh, so when we talk about immediate relatives refer to the spouses of US citizens or parents of US citizens. So spouses or parents of US citizens do not have any problem. They don't have any wait times. And when we specifically say family sponsored preferences, there are four categories. So one is F1, the other one is F2, F3, and F4. And F1 refers to the sons and daughters of United States citizens who are unmarried. F2 refers to the spouses and children of green card holders. So you have a green card holder in the United States, and their spouse or their child is in some other country, and they need to apply for a green card for their spouses. So that is F2 category. And then you have the siblings of US citizens. So you have a US citizen, they can sponsor their siblings, their brother or their sister, and so on. So that is the F4 category. And usually, I mean, the timelines are extremely bad, the numbers that you just referred to. And the reason for that is there is a fixed quota. So every year there is a limit on how many number of people can come into this country in these categories. And what happens is the demand, there is too much of demand, and it exceeds the number of visas that are available, the number of green cards that are available under these categories. So when you're talking about, for example, India, so in India, if you have a US citizen and the US citizen is trying to apply for his sibling, brother or sister, so people who have applied a long time back in 2006, in July of 2006, those people are getting the green cards right now. So what that means is we're looking at about 18 years. So almost 18, 19 years. So if somebody who is a US citizen in 2006, they applied for their sibling in 2006, their siblings are getting the green card right now. And similarly, China, it's almost 2008. So almost again close to 16 years. Mexico is even bad. So siblings for any citizens who are US citizens, but their siblings are in Mexico, it's almost 24 years. So almost 24 years. The wait time is almost 24 years right now. So what this means is uh, the quotas. We have limited quotas, and you can, by law, by regulations, you cannot exceed those quotas. So Department of State, the consulates are limited in only approving those number of visas per year. And when you have more demand from certain countries, because again there are something called country quotas, every country can only get 7% of the quota that is available. So once you hit that 7% quota, that country stops. You cannot give more visas than allowed. So this per country quota limits are causing a major issue to these four countries: China, India, Mexico, and Philippines, when it comes to family-based immigration. And going into the future, I don't think there'll be any kind of an immigration law that would change on the family-based side to increase these quotas, because there is nothing, no bill that is outstanding that is pretty recent where they're talking about increasing their quota, these quotas, these family-based quotas. So what this means is, until we probably have any kind of an immigration law passed, we will continue to see this extended wait times, and until these country quotas are either removed or the numbers are increased, we do anticipate to see this kind of wait times at least in the next couple of years.
Absolutely. Thank you so much, Chand, for putting this up, because, many hopefuls out there keep asking, are we going to have better news in the next visa bulletin or the next one or before the fiscal year this time? But seems like it's not going to change too soon. So thank you at least for being so clear about that. And Chand, looking at the EB2 and the EB3 for India and China as well, the wait is around 12 years. And what is your advice for people in these categories who are stuck in the backlog? And if they can switch categories or upgrade their cases, what do you advise?
Sure. So again, when we come to the EB2, EB3, or EB1, the employment-based categories, again, the wait time is pretty bad. And again, in general, what happens is the fiscal year for USCIS, for the government agencies, starts from October 1st. So what that means is when you have the green cards, what USCIS does is, when it's the first fiscal quarter, the first fiscal quarter starts in October 1st. So October 1st is where all the numbers are opened up, and the numbers, as we go through the quarters, the first quarter, second quarter, third quarter, the numbers are getting depleted. And when we come to the final quarters, so right now the July bulletin got opened up. So July, August, September. So this is the final fiscal quarter for the year. Normally what happens is most of the numbers are already used up, and it's only in October that we get the numbers back again. So historically, it is pretty normal that when it comes to the end of the year, end of the fiscal year, so theoretically, July, August, September is the fourth quarter, the final fiscal quarter of the government fiscal year. So the visa bulletins normally don't move. So last month and the month before that, and the July bulletin that just came out, it is kind of pretty disheartening because we have not seen any kind of a movement. And if you look at India, the only dates that have moved are EB3, and even EB3 only moved by just 1 week. It is in 2013. So from April 15th, 2013, it went to 22nd April 2013, just a week. So it is not really great movement. The other categories, EB1, EB2, the other categories, they have not even moved yet, not in a single day. So again, the main thing is everybody's watching out for the October Visa Bulletin. October Visa Bulletin will definitely see some kind of a forward movement. It will not be very, very substantial, but definitely not what we are seeing in the last couple of months. So in terms of what people can do, because the EB categories are backlogged. Again, we are running into the same problem. There is a limited number of green cards that are available. So we have 140,000 per year. That is what is available in the entire EB1, EB2, EB3, EB4, EB5. And out of that 140,000, for example, India is only eligible to get 7% of that quota. And the reason for that is green cards are based on country of birth. It is not based on citizenship. It is based on country of birth. So if somebody was born in India or born in China, so right now, even if they became a citizen of Canada or became a citizen of Australia, it does not matter. It is based on country of birth. So when you have your birth from one of the countries where we have a huge backlog, like India or China, so the other options that are typically available are, people should be looking at EB1 option. EB1 definitely has faster movement. The other option is EB5. So what a lot of people are doing nowadays is they're really exploring at EB1 option, they're really exploring at EB5 option. And when you look at EB5 option, there is a $800,000 investment, and then there is $1,050,000 investment. So there is something called set aside categories. So the EB5, if you are looking at the set aside categories, the dates are still current for all the countries. So even if you're from China or from India or any of these backlogged countries, if you're investing into EB5 but only the set aside categories, the dates are still current. But if you're investing into the EB5 unreserved categories, the dates are backlogged for India. So anybody that is exploring at a faster green card approach, definitely look at the EB5 option, but look at the set aside categories. When we talk about the set aside categories, we're talking about the rural category, we're talking about the targeted employment category, or we're talking about the infrastructure category. So that is one option that a lot of people have been exploring in the last couple of months. EB1, I'm seeing a lot of people become successful in the EB1 option. So when we talk about EB1 option, we're talking about EB1 extraordinary ability, which is EB1A, where I'm seeing a lot of people explore the EB1A option. The reason is, if you look at people from India or China, they have been in this country for such a long time, 10, 15, 20 years. So they have contributed a lot, and not only contributions, it is all documented. Maybe they have published papers. Maybe they have attended a lot of good conferences. They've presented some good papers in the conferences. Maybe they wrote some papers. Some people have applied for patents. So in the last 10, 15 years, if somebody has been in US making very, very good salary, they're highly respectful in their profession. EB1A, extraordinary ability, is a good category. So that is something what everybody should explore, especially if they have good resume to back up. So when we talk about good resume, we're talking about a high salary. We're talking about, do you have any papers? Have you been a judge in any conferences? Have you talked in good conferences? And do you have some contributions to the industry that are very valuable? And when we talk about contributions, the government, they're really looking at some targeted occupations. So if you're working in, like, some say data science, artificial intelligence, something that would really help the nation, the country, you will be given a preference. So always, if you do think that you have extraordinary ability, that is something for you to explore and see if you qualify for EB1A. There is also EB1B, which is for outstanding researcher. So if you have like a PhD and you have good research going on, EB1B is a good option. But normally I've been seeing EB1A being more available for people who are in the IT industry. And also EB1C. So if you're working in a managerial capacity and your company is a multinational company, your company has offices abroad. If you work as a manager abroad for at least 1 year out of the last 3 years, and then you want to come back to US and then work in US in a managerial category, EB1C is a great option, and a lot of people have been exploring the EB1C option. So this is something that I think all of you should explore. And we also have the EB2, EB3 downgrade and upgrade. But again, EB2 is pretty bad. EB3 is pretty bad because EB2 and EB3 both are extremely backlogged for India. The downgrade option right now is not a great option because both EB2 and EB3 are at a similar point in 2013. Both are backlogged. So the downgrade option that did work for a couple of folks a couple of years back is not really a great option. So again, anybody that has an approval under EB2 or EB3 category, an I-140, if you do apply for EB1 category and you do get an approval, what USCIS would do is they do something called porting of your priority date. So what that means is they will take your EB2 or EB3 priority date and they will put it on your EB1 approval. So anybody that qualifies for EB1 right now, if you do EB1, you can take advantage of porting of the priority date. Okay, so by taking advantage of the priority date, so whatever was your EB2 or EB3 priority date in the past, you can get that ported over to your EB1 approval. So I think that is the best option that I would advise people in this backlogged areas to take a look at. Look at EB1A option, look at EB5 option. And right now, EB5 I think is a great option, but I think even EB5 in about probably 6 months to 1 year, you will see retrogression. So if you are interested in EB5, I think now is a great time. But again, EB5 is not easy. You have to spend a lot of money. And not only that, you have to do a lot of vetting. You have to look at the project. You have to really be comfortable investing into that project. And that takes time. So anybody that is thinking about EB5, start your research and try to look at a lot of projects. Don't look at one EB5 project, look at multiple EB5 projects so you can analyze the risk and see what works out for you.
Thank you so much, Chand, for giving us that advice. I think this is what people wanted to hear as well. So thank you for that. And there is so much more to talk about. I just quickly want to say hello to Karthik. I am Yugandhar, RK. Thank you so much, Jadav, for joining us, and we are going to take up your questions a little later in the show. But for now, stay with us. And I hope you're enjoying this conversation we're having with Attorney Chand Parvathaneni. So please do not forget to subscribe to our channel if you haven't as yet. To all viewers out there, and yes, also ring that bell so that whenever we have discussions like these, you're also notified. And yes, check us out not just on YouTube but also on LinkedIn, Facebook, X, and on Instagram. So also, if you want to have a consultation with Attorney Chand Parvathaneni, maybe you need some advice or some guidance on your visa. So why not contact him? And you can check out the contact details in this link which is displayed on the screen. Okay, Chan. So I wanted to talk about for Mexico and Philippines. Some family-based categories show wait time over 20 years, and it's really very long. So is there any realistic legal workaround for families who don't want to wait that long, by any chance?
Sure. So for anybody who's going through the family-based immigration from Mexico or Philippines, the good thing for them is their employment-based categories are not as bad as their family-based categories. So anybody from Mexico or Philippines who have a case pending under family-based, they should be looking at employment-based immigration because their EB2, their EB3, their EB1 is not as backlogged as the family-based. The employment based is backlogged heavily for India, but not for Mexico and Philippines. So that's something what they should be looking at. Definitely see if that is an option. And another one they should be looking at is looking at family based immigration or immediate relative category. So in case they qualify either through a relative or either through marriage, immediate relative category is one option because sometimes people get married to US citizens. Sometimes uh, something else happens. So immediate relative category is used for the spouses of US citizens or parents of US citizens or children of US citizens. So at some point of time, if they do qualify as an immediate relative, IR, there is no numerical cap and they move like immediately. So if they do qualify under immediate relative category, that's the best option because they simply can convert their F1, F2, F3, F4 to immediate relative. And then that becomes very fast. There is no numerical cap. And what that means is it is immediate. There is no waiting time other than the processing time. So that is one best option. And the final option, it's you can also think about using a non-immigrant visa. When you, if you are in the queue for F1, F2, F3, F4, typically there are some dual intent visas. So dual intent visas such as H1. So you can probably still come to US, work in US in a non-immigrant status using a dual intent visa. So maybe that's another approach that some people can take, because you might be qualified to work in US. So explore the dual intent visas. So these are some of the ways where you might explore and see if it works out for you.
Interesting. Thank you so much, Chand, for that. And looks good for Mexico and Philippines that they have an option to check out the employment based preferences. So, yes, thank you for that, Chand. And well, we are here to also discuss about our second topic of discussion today, that is the I-94. And why is it maintaining a valid I-94 status so critical? It's very important. So, we will touch up on that as well. But let's quickly take up a few questions from our audience. Let's not keep them waiting too long. So, Ricky is asking, for those on H1B, is there a way to print I-94 separately apart from it being mentioned on the H1B notice?
So when we talk about I-94, so there are two ways you get your I-94. One is through CBP, Customs and Border Patrol. You just go to the website. You just type in I-94 online. You go to the website, and you can get a CBP issued I-94. So the CBP issued I-94, the only information it will have is so anytime you come into the country through port of entry, that is the time the I-94 from CBP gets generated. So whenever you travel into the country, you get the CBP I-94. And when you apply for extensions, or when you apply for transfers, or when you apply for any petition with USCIS or any application with USCIS, USCIS also issues you the I-94, and that is the I-94 on your 797, I think, that you're talking about. And what you should be doing is you should keep a copy of your CBP I-94, which will not change until you travel out of the country and come back. So if you don't travel, that I-94 stays as is. You should keep a copy of that. And then you should also keep the I-94 that is issued by USCIS. And then you should always see what is the latest one. And whatever is the latest one is the valid I-94. And that is something called last action rule. We'll talk more about it in this session. So from your perspective, you keep both the CBP I-94 that you can download at any point of time from the CBP website. And then you will have a USCIS issued one, which will be on your I-797. You should always keep a copy of both of them. And then you should always use the last action rule to determine what is most recent. And that most recent one is the one that you should use.
Thank you so much, Chand, for taking that up for Ricky. And Ricky, I hope you got your answer. Thank you for participating today as well. Let's take up this one from Jadhav now. For individuals transitioning from a non immigrant visa to an immigrant visa, what role does the I-94 status play in that process, and how does it impact the timeline for receiving the green card?
Sure. So I-94 is typically for non-immigrants. So anybody that's in any kind of a visa, they always will have an I-94. And I-94 basically simply says one thing. It will have an end date, and it simply says that you are allowed to stay in this country until that end date. So you always look at your most recent I-94. And since you're on a non-immigrant visa, that is the date you're supposed to depart the country. Unless, in your case, you said you're transitioning from non-immigrant visa to immigrant visa. The way you do it is you file a 485. So if you have a 485 pending, if the 485 is pending, then you are allowed to stay even if your I-94 expires. So if you file your 485 before your I-94 expires, then what it means is, as long as your I-485, the non-frivolous application, a legitimate 485 application, as long as it is pending, and you are allowed to stay in the country. So when you're transitioning to immigrant visa, which is basically the green card, it is more about the 485. And as long as the 485 is pending, typically you should be allowed to stay in the country. And in terms of impacting the timeline for receiving the green card, again, 485s come under different categories. It could be for family based, it could be for employment based, and so on. And depending on your category, it takes time. If it is an employment based category, if it is or any kind of a category where your dates are current, more than likely, if your dates are current, 6 to 12 months is what typically you can expect for the 485 to get approved or get adjudicated. But again, sometimes what happens is there is retrogression, the dates go back. If the dates go back, what happens is you will not get a green card. USCIS will not adjudicate 485. They will keep 485 in a pending status, they will let you apply for EAD 765 or 131 advance parole. So you keep using those documents to stay back in the country. And even if your I-94 expires, if your 485 is pending, you can just stay back in the country and work as per your EAD card. You can travel out of the country using your advance parole and keep doing it. So I-94 is more for people who are on non-immigrant status. And if you're on non-immigrant status and you don't have a 485 pending, you do have to make sure that you can't overstay your I-94.
Okay. Thank you so much for taking that up, Chand, for Jadav. And Jadav, do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And folks, you can keep participating, keep commenting with your questions, or you can dial this number 425-436-6335, and the access code is 988888. Join us to ask your questions, and maybe you can treat this as a short consultation with Attorney Chand Parvathaneni as well. So let's go on now and take this question from Karthik. He says, "Hello, Chand. I would really appreciate if you take this question. I was wondering if part time work is allowed on a TN visa. Additionally, can an individual hold two jobs on two different TN visas?"
So when we talk about TN visa and you want to do a part-time job, so you're already in the country on TN, and then you have a second job, a concurrent job. If you want to do a concurrent job, your employer will have to file an I-129. So you're in the country. So either from Mexico or from Canada, you came into the country, you have a TN I-94, and say you want to do a second job, a concurrent job. The way you would do it is your employer has to file an I-129. They do have to let USCIS know it is a concurrent job. So there is an option on I-129 where on the second page where it says what kind of an employment it is, you would have to mark it as concurrent. And then additionally on the I-129, on one of the pages, page 5, you will be able to let USCIS know it is a part-time job, and you'll also be able to let USCIS know how many number of hours you'll be working in this concurrent part-time job. The thing is, on TN, you do have to get an approval before you can start the job. On H1B, if it is concurrent, you get a receipt, you can start the concurrent job. If it is TN and you want to do a concurrent job, if you do your employer will have to apply the I-129, wait for the approval. Once you get an approval, because you're notifying USCIS, because USCIS is allowing you by approving the TN case, you should be able to do the concurrent job.
Okay. Thank you so much, Chand, for taking that up for Karthik. And let's take this one now from I am Ugandhar. Hi, sir. My H1B petition has been approved on 2024. Stamping not yet completed. If I miss this year's stamping, will have to again go for lottery system? That's the question.
Sure. So normally the rule is once you get your petition approved through the lottery, through the process, you are counted against the cap. So the way it works is because you're counted against the cap, you now have 6 years to work on H1B. And if you have not used the 6 years, you are technically cap exempt. So what that means is you don't have to go through the lottery if the case has not been revoked. There is no fraud in the old approval. You are technically cap exempt. Say in 2028, say after 4 years, you have another employer who wants to file a H1B for you. They don't have to put you through the lottery. So they can simply file a H1B, ask for cap exemption based on the fact that you have been counted against the cap. So in your case, you have been counted against the cap in 2024. So based on that, you should be cap exempt. That being said, in case you're out of the country for more than a year, USCIS does allow you to go through the lottery once again and recapture again. You will be able to get your entire 6 years. So, but again, in your case, if there is no problem with the old approval, the approval has not been revoked, because you've been counted in the cap, because you got an approval, a new employer should be able to file a cap exempt petition without going through the lottery.
That sounds very interesting and good news, I guess, for I am Ugandhar. Thank you for participating with your question. And let's take this one now quickly for RK. I hope you're doing good, RK. And he's asking, do you see retrogression on any of the dates for the rest of the fiscal year? Second H1B possible? I think he's talking about the lottery. And do you see companies not filing, which would increase the chances? Lottery.
Sure, sure.
That was in parts, but
So
I guess you got it. Yeah.
yeah. So when we talk about retrogression, say we talk, for example, we're talking about the dates for India, because India is a country which is like heavily backlogged. The dates are unfortunately extremely bad. I mean, we are looking at 2013. I don't think, I mean, again, even if there's retrogression, I don't think, I mean, there's like nothing else to go back, because since 2020, that is where the dates have been stuck at. I mean, in 2020 during COVID time, the dates went ahead. But again, I mean, again, most of the people from before 2012, they got their green cards, because in 2020, the dates were current for 2012 and so on. So most of the people did get their green cards. So the number before 2013, it is very low. So there are very few people before 2013 who have not received the green card. So there is not really much to retrogress for EB2 and EB3 for India, because the dates are already very bad, extremely bad. That being said, normally what happens is when we go into the last 1-2 visa bulletins of the fiscal year, because September is the last visa bulletin for this fiscal year. So, I mean, even if there is retrogression, I mean, again, it will come back up in October. So October, again, they will move the dates forward. So because the dates are so bad, I don't really think that there is any scope to really send the dates back. So maybe in the last visa bulletin, in the September visa bulletin, maybe they will move the dates a little bit back. But in October, I think they will again move it forward. So because the dates are really so bad, I don't think there is anything to retrogress any further in at least EB2 and EB3 categories. And
Thank you so
the
much. Yeah. Sorry, Chand.
the
Go
other
on.
part of the question, I think, regarding H1B. So regarding H1B, I definitely think there will be a second lottery, because we are seeing a lot of petitions getting filed, but I'm also seeing a lot of petitions not getting filed. Maybe because of the economy, maybe because of various reasons. But because I am seeing a lot of people not file, I do think there's a second lottery. And if you say like, are majority of the people not filing? No, I think majority of the people are still filing. But I at least think that there'll be some percentage of people that are not filing, which means there is a good scope for a second lottery. So I definitely think that there will be a second lottery. I would not say it will be a huge number of selections, but I definitely think that there will be reasonable number of selections, just similar to last year. Because if you look at the last year's second lottery and the year before that second lottery, last year we had a second lottery, but not too many selections. But the year prior to that, we did have a lot of selections. So I think there will be a second lottery. Uh, and again, I don't think it will be like too many selections, but at least I think we will see some reasonable number of candidates getting selected in the second lottery.
Yes, looking forward, Chand, and I hope so also. It's already mid June. So, if by any chance we have the second lottery, by when do you expect it to happen?
So normally it will be in the last week of July or the first 10 days of August. If they don't announce anything by first 10 days of August, more than likely you can assume that maybe not. But again, first couple of days of August, starting from end of July to August 15th is when I think you can expect some news about second lottery.
Okay, okay. Thank you so much, Chand, for taking that up. And let's take this one from Rag, and then we'll continue with some of our questions as well. Rag is asking, what are the consequences if I get a concurrent H1B and I work for the second company? Will it have any repercussions with the green card filing or issues at port of entry?
Sure. So if somebody gets an approval through concurrent H1B, all that means is if they want to go ahead and work on that second job, concurrent H1B, they are allowed by USCIS to perform that job. But again, employee does not have to go and start that job. If they don't want to join that job, they can resign. They don't even have to join the job. That being said, from a company perspective, what we always say is if you don't require that H1B, you should be revoking that H1B. The reason is if you keep the H1B active, tomorrow you might have a site visit and then you have to explain. So if you know the employee doesn't want to start, a good practice is the employer should go and revoke that H1B. So the employee does not have to answer in the future what happened, and the employer does not have to worry about having any liability for pay or anything. So, no, there is no requirement that just because you got a concurrent H1B that you have to go and start. Because if you're not interested in starting, let the employer know, and the employer should go through the formal process of notifying USCIS and withdrawing the H1B. That is the cleanest way. But the only time you'll have a problem with USCIS or consulate is if you work without authorization. So if you don't get proper authorization and you start working on a job, that is when you'll have a problem. But when you have an approval, you don't want to start that job, that is fine, as long as you maintain status, which means in your full-time other H1B, you are working as per the required means you're maintaining status, you're maintaining your H1B status. If you don't start your concurrent H1B, that is fine. Resign that job. Let the company know that you don't want to join that job.
Okay, all the best, Rag, and thank you for participating with your question. And folks out there, stay with us. We will take up some more of your questions a little later if possible. But now, Chand, I have a few more questions for you. So if you could tell us, for those with F, J, or M visas whose I-94 says D/slash S instead of specific date. So, could you explain what that really means and how it affects their stay or ability to apply for a green card?
Sure. So when we see a lot of people, their I-94 will always have like an end date, like somebody on H1, somebody on L1, somebody on any other non-immigrant visa. Typically, you will see an end date for I-94. But when it comes to the student categories, F, J, or M, uh, normally what happens is they will see something called D by S on their I-94. D by S means duration of status. So what is happening is they don't put an end date because they're not really sure when the program expires. For example, somebody is a student. It is very hard to predict the exact end date on their status. So what typically happens is they simply put it as duration of status. And what that means is as long as the student is participating in the program, for example, a student, as long as they're enrolled in the full-time program, as long as their service record is valid, as long as they are maintaining their OPT or STEM OPT, they are allowed to stay in the country. So the minute their student program ends, or their OPT ends, or their STEM OPT ends, that is when their status ends. So because it is very hard to predict that end date on the day of arrival, they'll simply get D by S. So whenever somebody sees D by S, all it simply means is you maintain your F1 status, or your J1 status, or your M1 status. As long as you're continuing the program, you are good. The day you fail to maintain status, or the day your program ends, that is the day you fall out of status and you should not stay back in the country unless you have a grace period. For example, F1 students have like a 60-day grace period after their program ends, and so on. So D by S simply means maintain the requirements of your program. The day your program ends, depart the country. And when you talk about green card, before their program ends, they can always qualify for applying for 485. So for some reason, if the company files for I-140 and they're allowed to file for 485, say somebody's from a country where the dates are the current, they might be able to file for a 485 even while they're on student status, assuming they have always maintained their status in the country. So anybody that is qualified for adjustment of status, they are allowed to file for 485 even while they're on F1, assuming that they have always maintained status, and assuming that on the day of entry, the day of their initial entry, they did not have an immigrant intent. And that is the case, they should be able to file for adjustment of status. So again, the bottom line is anybody that is on F1, always comply with your service. Always consult your DSO. Always make sure that you know when your service is getting terminated. So even though it is saying duration of status, it is not indefinite. It is based on your program participation.
Okay. Thank you so much, Chand, for taking that up for us. And folks, do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. Check us out not just here on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. And I'm sure if you're resonating with this, do not also forget to share this content with your friends and folks who could benefit most, with our content here and this conversation we're having, of course, today with Attorney Chand Parvathaneni. So, Chand, we do have more questions, and I'd like to take this next one, which is if someone overstays beyond the date on their I-94, even by a few days, what are the real consequences? And is there any way to correct it without triggering future issues?
Sure. So normally, what happens is if somebody overstays their I-94, they are at risk. That being said, if you do not cross 180 days, most of the time, if you have some genuine reason, you should probably be able to get through. And I'll talk about some of the ways that we can do it. If you cross 180 days and you overstayed your I-94 by more than 180 days, you are at risk for mandatory bars. And that is when you'll run into all kinds of issues. And normally, what do you do? So, because if it is not intentional and somebody made an accidental mistake and they overstayed their I-94, how do you resolve it? So normally, if I see somebody has not crossed 180 days, the easiest option is you depart the country and then you re-enter the country with another inspection, with another CBP inspection, or you go to the country, go out for visa stamping. If it is less than 180 days, most of the time you should not have an issue. You'll be able to overcome. Either if you need to get a new visa, you might be able. I mean, I don't typically see problems if you don't cross 180 days. If you cross 180 days, that is when you'll have mandatory bars. So what you normally do at that point of time is there is something called NPT, non pro tunc. So there is something called NPT where you go back to USCIS, you tell what exactly has happened, and you prove to them that it is not intentional, and you show them the reasons why this happened, and you also have to show that you're not in any removal proceedings. You also have to show that you have not done any crimes or anything else. So if all is good, this NPT process is a discretionary process. So USCIS normally, if everything is good, they see a good reason, they approve NPT. So going through this NPT process, non-pro tunc, is one way where you let USCIS know and you fix the problem. So NPT is one way where you go back to USCIS, fix the problem, or the other option is go out of the country, re-enter to get a new I-94. So if you go out of the country, you re-enter, that old issue with I-94 normally is resolved. So in the future, they're not going to come back and cause you a problem if you left the country and you re-entered and got a new I-94 issued to you. So these are the two typical ways that people solve the problems, either by re-entering, getting a new I-94, or by filing an NPT, going back to USCIS and working with USCIS to get an approval for NPT.
Okay. All right, Chan. Thank you so much for taking that up for us. And I also had to tell you that many of our viewers are having trouble locating their I-94 online. So, what are some practical steps that they can take if the system doesn't pull up their records?
Sure. And again, this is very important. Everybody should be able to pull up their I-94 record online, because any future extensions, any future applications, you always have to show your CBP I-94. It is very important. And sometimes, if you are not able to pull up your I-94 records, you apply with USCIS. USCIS sometimes will say that they're not finding a record. They could even deny a case. So what you should do is go to CBP online. You just Google I-94 online. You'll see a link, a cbp.gov link. Try to put your passport information and pull up your I-94. If you're not able to pull up, immediately contact CBP. And the way you do it is so the big cities will have a CBP office at the airport. So normally you should reach out to them. You can call them, you can email them, but most of the time they will say, come over to the office, come over in person. So go to the office, let the officer know when you came into the country, the CBP officer, and let them know that your I-94 is not pulling up, and they will be able to assist you. Not only that, sometimes we also see is when people pull up their I-94 records, sometimes some data is wrong. Maybe the end date is wrong. Maybe something is wrong. So it is everybody's responsibility that whenever they travel back into the country, they land in the country, within 2 or 3 days, look at your I-94 record. If you're not able to pull up your I-94 record, or you see some issue with your I-94 record, such as wrong end date on your I-94, immediately reach out to CBP. If you reach out to them immediately, they will fix the problem. If you delay the process, sometimes they will cause an issue. So if anybody is not able to download their I-94 record, reach out to the CBP office, or let your attorney. I mean, if you're working on H1B, let your company's attorney know about it. And it is highly important that you do have your CBP I-94. Every non-immigrant, anybody on a non-immigrant visa should have their I-94. But if not, there is a way to get it rectified through CBP office. Okay, so make sure you do it. If not, it is going to cause a problem down the line when you apply for extensions.
Okay. Well, thank you so much. It's very important, friends. So I really hope that you were paying attention and taking notes. And even if not, that let me tell you that you can always go back and watch this episode again even after the stream has ended. So thank you for that, and do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And also, if you want to have a one-on-one consultation with Attorney Chand, visit this link which is displayed on the screen. So, Chand, we do have more questions and also some from our Facebook groups as well. But before that, I wanted you to tell us, if someone overstays beyond their date. Oh, sorry, in one of the real cases, a professional entered the US on an O1 visa, but his I-94 was issued with the wrong expiry date, leading to a 9-month overstay and triggering a 3-year bar. So, what should travelers and visa holders do right after entry to avoid devastating errors such as this one? And how quickly can a mistake like that be
Yeah.
corrected if they're caught early?
Yeah. Normally, if you catch the mistake early, CBP will work with you. So, and what that means is everybody, they have this responsibility that they check their I-94. I would say at least 2 or 3 days within their entry into the country. If you check it immediately, normally there are like two options. One, you can email to CBP. Sometimes when you email, they're fixing it. Sometimes they don't. And if they don't, you go walk into the CBP office. So if you entered somewhere, like port of entry, you entered in Dallas, you reach out to the Dallas Fort Worth Airport's CBP office. So they have an address. You look it up online, you'll see the address. You just simply go to the address and talk to the CBP, let them know this is when you entered the country and you're seeing this issue. If you do it right away, what the CBP officer does is they'll look at the approval, they'll look at what's going on. Most of the time, they will fix the problem. It is only when you don't look at, because people do have the they are required to check their I-94s. So if they don't check, and it's a long time, and like in this case, they realize after a very very long time after their I-94 expired. Now, even if they go to CBP office, they will sometimes claim that it is their mistake that they overstayed and cause major issues. So to avoid that, the simple solution is anytime you go out of the country, you come back into the country. So anytime you're coming back from a foreign country back to US, you land into the country. Everybody has to go through a CBP inspection. Everybody, even US citizens, have to go through a CBP inspection because you have to go through the port of entry inspection. So once you come out, any non-immigrant, you simply go to the CBP website. It is online. You just type in your passport number, your date of birth, your I-94 will pull up. Look at the record. If it shows wrong information or if it does not pull up, simply contact CBP. They will fix the problem. So, I mean, again, it's a good, educational thing that look at your I-94. There is a mistake. Reach out to CBP, local CBP at the airport. They will fix the problem.
Okay. Thank you so much for taking that up for us, Chand. And also, I had another case study which is from our Visa Bulletin point of view. So, let's say a US citizen filed an F3 petition for a married child over 21 years for their son who is in India back in 2013. So, according to the current Visa Bulletin, the final action date for F3 India is around 2009, but the date for filing is 2010. So this family is now unsure whether they can begin NVC processing or if they need to wait longer. If you can just walk us through, what these two dates really mean in practice and how families in this situation can, plan ahead, especially when they're stuck and waiting years, after filing is like this.
Right. So normally when you're going through this F3 process, what happens is you get an I-130 approval and then it is stuck in NVC. And until the dates are current, they will not even send it to the consulate. So when you see the dates are current, at least in the second chart, that is the time where you reach out to reach out to NVC and work with NVC to make sure they're filling up all the documents, they're paying the immigrant fees, and they're working with NVC to send their paperwork to the consulate. And that is what they should be doing if the dates are current. And because that again takes some time for the interview to be set up. And that being said, there is something called Child Protection Act. So according to the Child Protection Act, the dates will be frozen. So even if somebody is crossing 21, based on certain rules, the dates will be frozen. So if some particular things happened in some particular sequence, based on the time they had to wait for that I-130 approval, all that period will be added up. So the first thing they'll be looking at is to see when their actual Child Protection Act's ages, to see if their age has been frozen or not, and then work with NVC simultaneously to get things over to the consulate and get a visa interview. And that being said, it is unfortunate that the dates are so backlogged, more than 15, 16 years for these F1, F2, F3, F4 categories. But again, I mean, all they can do is patiently wait for the visa bulletins. The day they see the date current in the second chart, contact NVC, work with NVC to at least making sure that all the documents are uploaded. They pay the immigrant visa fees on the NVC website, and things start moving towards the consulate. But if the dates are not even current, there is nothing that they can do, and they just have to wait.
Okay. Thank you so much, Chand, for taking that up as well. And we do have some Facebook questions from our groups. So let's quickly take a few of them first. And this first one is from an anonymous participant asking, we filed I-485 and I-30 concurrently for my parents. We got RFE for not sufficient income and had to co-sponsor my sister-in-law. We have interview in 2 days. What to expect in the interview? I'm very nervous.
Sure. So a lot of, so when somebody applies for a family-based green card, so in this case, U.S. citizen applied for their parents. So anybody that is applying for a green card, we do have to prove that they're not a public charge. So a lot of people think that a lot of these immigrants are coming into the country and the country has to bear all their expenses. No. So the reality is, whoever is sponsoring, in this case, the child is sponsoring their green card. So what typically happens is, to get the green card, they are actually required to show that they have enough finances, enough income to ensure that they don't become a public charge. So they're not a burden on the government. So in this case, what happened is they don't have sufficient income, but the government says that you can always use a joint sponsor. So even if the US citizen does not have enough income, they can always use a joint sponsor. And the joint sponsor, basically what they do is they also sign the I-864 as a joint sponsor. And when they sign the I-864 as a joint sponsor, they show their income, and they will be able to show that because they have enough income and because they are giving those attestations that they will sponsor uh, uh, the immigrants, USCI should not have a problem. So what to expect? So what to expect is they will look at the sister-in-law's income. They will make sure the sister-in-law's I-864 is properly filed as a joint sponsor, and if that is done, they should not have any problem. So I think it is simply the question of having a joint sponsor. In this case, looks like they already have a joint sponsor, the sister-in-law. And by looking at the sister-in-law's income, I don't think they will have any problem with getting the green card for their parents.
Okay. And I think by now the interview is also done. I really hope they got through it. So now let's take this next one. Hello, has anyone had a situation like this? My mother in law had an interview for I 485 and was told she was approved at the interview, and few months passed by and was sent a letter that more evidence was required to decide on her case.
Yeah, it does happen a lot of times. I've seen this a lot because in the interview they say it's approved, but what happens is, again, something shows up on the background, and more than likely it is something small. Because sometimes I've seen, like, hey, can you send us the I-94 from so and so time, or can you show that somebody has maintained valid status from that time, or sometimes something very very simple. So I did have cases where this happened, where at the interview they were said everything was good, and then they got an RFE. But most of the time, my guess is that RFE is something very simple, because at the time of interview, if they said the case was approved, probably passed all the background checks, but they found something, and that's why they got an RFE. I would not worry about it. I mean, as soon as you get the RFEs, immediately respond back to the RFE. Most of the time, the 485 RFEs, if you respond back, they are very quick at approving those 485s once you submit all the documents that are required by the RFE.
Okay. Well, thank you so much, Chant, for taking that up. Now, this next one is from Andre. Just a question: what kind of questions should a under 12 child expect at on interview?
Most of the time, because you'll have the parent. I don't think. I've not seen children under 12. I've not been in any interviews where a child under 12 was asked any questions. I'm not sure. But again, I'm not. It depends on the category they're applying, and it also depends on what kind of a filing it is, and so on. But again, most of the time, I think it'll be on the category. What kind of a category they're qualified uh, for that particular benefit? Is it a parent-child kind of a green card? Is it a green card-child kind of a relationship? Or is it like a employment-based 485? Or is it something else? So I'm not sure what exactly is the benefit they're seeking, because a lot depends on the benefit they are seeking. and what kind of interview it is. Is it a green card interview? Is it N600 interview? Is it N400 interview, and so on? Because if it is a child and if it is something like an N600, they typically waive those kind of interviews or have their parents come for the interviews.
All right. Thank you so much, Chand, for taking this up for Andre. This next one is from Dave. I am on my 14th month waiting for I-130 to be processed. Is this normal?
Uh, Nowadays, it's normal. I mean, I-130 is like extremely, extremely slow. So previously, when I-130 was done for somebody who's like spouse of a US citizen or parent of a US citizen, they used to be very, very quick. But the I-130 is for sibling quotas, like for somebody who's like a sibling of a US citizen. It used to take time. Even before it used to take like 3-4 years for sibling I-130s. Nowadays, even for immediate relatives as in like spouses of US citizens, even for them, the I-130 is taking a very long time, and I'm not seeing any I-130s, standalone I-130s get processed before a year. And the USCIS website is taking as long as 24 months. So I think anywhere between 1 to 2 years is what somebody can expect their I-130 to be approved, and looks like nowadays it is normal. And what I think everybody should be doing is go to the USCIS website. You will be able to look up the processing times, and processing times differ based on where your I-130 is. There are multiple service centers with USCIS. So look at where your I-130 is and look at the timelines for that particular service center, and you'll be able to know. But again, I think that is what you're seeing is pretty much normal nowadays.
Okay. So delays have become very normal now. Has it doubled by any chance? Like, suppose it was like 6 months back. If it was like 6 months, has it become like a year now?
I mean, it's not anything to do with the current administration, because the I-130 backlogs, I've started seeing it like almost like from last
Yeah.
2 years. From the last 2 years, I think things have been pretty slow. So even last year, we were looking at like over a year timeline for I-130s. So I-130s have started going, have been taking a little bit longer time, and looks like, I mean, for the last couple of years, they have been bad. And this year, I think it's going to be even worse because all the backlogs are accumulating, and on top of those backlogs, you have more applications. So I want that is one thing. Unfortunately, we don't have premium, so things are a little bit slow on that standalone I-130 side.
Okay. Well, thank you, Chan, for taking that up and for the detailed explanation. So this next one is from an anonymous participant. Is it safe to go to the biometrics appointment with everything that's going on?
So when we talk about biometrics, there are two kinds of things. One is like say the 485 biometrics. The other is very recently, starting from last, I would say 4 to 6 weeks, we have been getting RFEs, and I've seen like a whole bunch of RFEs, probably more than 10 RFEs, where you file for a benefit, either an I-140, either a H4 or a H1B, for example. We are getting hit with this biometric appointment notices, and then when I go back and talk to these people who got these biometric appointments, always every case that I have dealt with, they had some kind of a brush with the law. Sometimes like a DUI arrest, or sometimes like driving without a license kind of an arrest, sometimes like domestic violence. So whenever there is some kind of an arrest record, and they had some issue with the law in the past, looks like it's flagged. And USCIS, anybody, if anytime they see some kind of an issue, some kind of a criminal record, they're getting hit with these biometric appointments. And I did have like a couple of our own clients call us and say, hey, is it safe? Should I go? Because they know that they had this issue with some kind of a criminal infraction in the past. My answer is, if you're applying for a benefit, like either a H1B, H4, or I-140, you get hit with this biometrics appointment. I mean, I would say it is mandatory. You keep up that appointment, you do that appointment, because what we are seeing is right after they go to that appointment, after a few days, we're getting an RFE. And in the RFE, they're saying, yes, we did this background check, because biometrics is used to do a background check. Now USCIS is coming back and saying, yes, we did this biometric with this background check. We are seeing this criminal history, asking us to explain. And more than likely, that is what is going to happen. So I do strongly encourage people to follow up with the biometrics appointment, and say in the future you get an RFE because you had something that they found with the biometrics. You follow the legal process, answer the RFE. Again, the good thing is, say you go to the biometrics appointment, USCIS does not see anything incriminating, anything bad, then you're good. You're all set. But again, if they see something, you can expect an RFE where USCIS will ask you to explain that criminal infraction, give all the criminal records. So typically they ask for police records, they ask for all the court records. So you do have to submit all the certified police records and the court records, because these two are independent. And then you have to answer your RFE, prove that you have not done any crime that makes you deportable, because not all crimes are deportable. All crimes are bad, but some crimes are definitely deportable. And your whole thing is you do have to show USCIS what kind of a crime it is, and do you qualify for any kind of exceptions. So that is pretty much what's going to happen when you see these kind of biometrics appointment that are recently being given to a lot of people.
Well, that was very interesting. Thank you so much, Chand. And I do hope that you have a little more time to stay with us because we have so many questions and I just want to keep going if that's fine a little bit. So this is from Charlie asking, "Hi, I just filed I-130 for my 17-year-old son and unmarried 24-year-old son. Do I need to file also the I-130A? Thanks."
So typically, I-130A is for the spouses. So when you file for a spouse, I-130 for spouse, I-130A is typically required, not for children. And I've not seen the recent instructions, but typically it's not for the children. It is for the spouses. I might need to check back the instructions, but I don't think it is for your child if you're filing for an I-130.
All right. Thank you, Chand. All right, I think those were some of our questions from our Facebook groups, but we do have from our live audience as well. So let's take this one from Manya. Hi, Chand. This is regarding the H1B amendment. Do I need to file an amendment if I move with in MSA? I just moved 6 miles away from the initial work location, which is on LCA. Do I need to file AR11?
So when it comes to amendment, it's location, you're only moving 6 miles. So the only question for you is, are the job duties still the same or not? If the job duties, the work is still the same occupation, uh, you don't have to file an amendment, because the move is within the same metro area, only 6 miles away. So check with your employer to see if your duties are different. And if your duties are still the same, your pay is still the same, I don't think you'll have to file an amendment. There is no material change because it's only 6 miles away. But when it comes to AR11, AR11 is your address change. So anytime, anybody, including green card holders, if you ever move your address, even if it is a different apartment number, same apartment complex, but a different apartment number, anytime there is any kind of a residential address change, immediately within 10 days, file an AR11. You simply do it by going to the USCIS website. You can do it online. It is like a 5-minute kind of a thing. So AR11 is like you follow that whenever you change your residence. But amendment is not, I don't think it is required unless, in your case, especially unless you have different set of job duties.
All right. Thank you so much for taking that up for Manya. And Manya, I hope that you've gotten your answers. Folks out there, please do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And I'm sure, especially most of you who got your answers, don't forget to also share this content with your friends. So we have Sishu from Facebook. Thank you so much for joining us again. And he's saying this is actually a follow up to my question in the previous session. Okay. Welcome back. And a quick recap. The question, I recently had a client change within MSA region. Okay, I think we just took that up. So that was Sishu, I guess. Okay, let me read it anyway. And after considering my scenario, you suggested need not file an H1 amendment but instead do an LCA posting. When I asked employer about it, they mentioned LCA posting will be done only for fresh H1s and not for someone like me. I have my H1 started in October 2024. Would like to verify that info with you. Can you please confirm that? At this point, do I have anything else to do? When I go for the interview for H1 stamping, what documents should I carry as proof of evidence for not filing an amendment? And if you have any other suggestions for me to keep in mind.
Sure. So in terms of amendment, yes, you don't need to do an amendment. But regarding the LCA posting, you can Google it up, and there is a link. There is a clear DOL link where they talk about moves within the same metro area. So they clearly say that when you move within the same metro area, you don't have to do an amendment. So amendment is not required because there is no material change. But there is something called LCA posting. The reason they require that to be done is because people at the new work site, they need to be notified about a non-immigrant working and the conditions for that. So it's a DOL requirement, not a USCIS requirement, but a DOL requirement, and it is out there. There is a link from Department of Labor. So I mean, normally, again, check with your employer's lawyer, because they will have that link, and they will be able to send you that link where DOL clearly specifies that LCA posting. So all they have to do is simply put the LCA copy on the wall. That's all they have to do. They don't really have to do anything. It doesn't cost money. It's just a posting, and it is mandatory. There is you can Google it, and you'll more than likely find that link on the dol.gov's website. So don't use any third-party links. It is a DOL link. So use that link. That being said, in terms of a filing with USCIS, no, you're good. If you have a site visit, you should not have any problem in terms of your H1B employment.
All right. Thank you so much once again, Chishu from Facebook, for participating with your question. And thank you, Chand, for taking that up. And also, Chand, I think before we leave, if because with so many people entering through different ports, are you seeing an increase in I-94 errors lately? And what should travelers be especially mindful of, during entry?
Sure. I see a lot of issues. The reason is, I mean, again, what happens is people always think that their H1B approval or their H4 approval has a I-94. So when they come back into the country at port of entry, they just give their passport, and the passport probably has a visa from their old employer, because a lot of times people, they do transfers, and when they do a transfer, they get a H1B approval with a 3-year validity. The visa is probably from an old employer, so the visa will have a different end date. The I-94 has another end date. Sometimes the passports expire, so the passport expiration date is sometimes different. And what happens is, when they travel back into the country, they simply give their passport. They simply, and the US nowadays, CBP, they don't stamp the passport. They simply say yes, you're allowed in, and they expect people to look at their I-94 online. And a lot of times, what I see is people just assume that because their H1B approval has a different end date, they assume that the CBP officer also put the same end date on their I-94. But a lot of times, what CBP officers sometimes do is they match the end date on your passport, or sometimes they match the end date on your visa. Because sometimes it's a mistake. They don't look at the I-94 on your approval copy. So mistakes happen. So just to avoid that confusion, I do see it all the time. Every week, I at least have one case where the employee thinks that the I-94 is till the end date on their approval copy, but the CPP officer shortened the I-94 to the passport expiration date or the visa expiration date. Made a mistake probably sometimes. So people don't realize that. So yes, I do see this all the time, which is why we always have the burden. So like employee, you're traveling back to United States, you do have the burden to download the CBP I-94, because you see a mistake, CBP will correct it. But again, you do have to download and then look at it. In the olden days, what used to happen is they used to give a paper I-94 at the port of entry. You used to look immediately, spot a mistake. Nowadays, because it is online, people are not realizing that. So the simple solution is you come into the country, go to CBP website, download the I-94, keep it with you. Any mistake, they'll resolve it.
All right. Well, thank you so much, Chand, for taking that up, and for patiently actually taking up each of our questions today in this session. I wish we could continue on and on, but I think we will have to leave some of the questions for our next session. And I really hope to have you back soon again, Attorney Chand.
Sure. Thank you so much, Nipasa. It was very nice talking to you.
Same here, Chand. And all the best then, and see you soon. Folks out there, thank you so much for participating as well. If you want to have a one-on-one consultation with Attorney Chand, and you all you need to do is visit this link which is displayed on the screen, and yes, go check him out. Thank you so much, everyone, for joining us. And also, if you have any questions, or you want to get in touch with me for any questions which we can push it to our attorneys, you can reach out to me in my WhatsApp number as well. And my number is 408-335-6444. This is also my dial-in number. You can call me on this number. And my email is nipa@staffingme.com. So feel free to reach out to me. And yes, check us out. We are Immigration Talk Show. Our handle is at Immigration Talk Show here on YouTube. So subscribe to our channel, ring that bell so that whenever we have discussions like these, you do not miss out on any, because we have very important information to share with all you folks out there. And also check us out. We are on LinkedIn, Facebook, X, and on Instagram to stay connected with us. So thank you once again, everyone, and stay tuned on Immigration Talk Show because there's a lot more coming. Have a wonderful day.